Good morning, everyone. Welcome to the last CSA lecture, lunchtime lecture series. I am very happy to welcome Dr. Namita Wahi as our speaker. We have been looking forward to this lecture for a very long time. And I'm just very grateful that Dr. Wahi is able to talk to us today under the circumstances that Sarah spoke about right now, the unimaginable human toll of the COVID crisis that is happening in India at the moment. I want to take 2 minutes to introduce Dr. Wahi to all of you. Namita Wahi is a fellow at the Center for Policy Research in Delhi, India, where she leads the Land Rights Initiative. She is also a visiting fellow at the Center for Law and Social Transformation in Bergen. She holds an SJD or doctoral degree from the Harvard Law School, where her dissertation centered on the right to property and economic development in India, which is a topic we will be learning more about today. Namita's research interests are broadly in the areas of property rights, social and economic rights, and eminent domain or expropriation law. She has written extensively on these issues in various academic journals and edited volumes, as well as newspapers and magazine reports. Namita has taught courses in these areas at Harvard University, both in the law school and the Department of Government, and at the National University of Juridical Sciences in Kolkata, India. Dr. Wahi was recently awarded the very prestigious New India Fellowship for her forthcoming book on the history of the fundamental right to property in the Indian Constitution, which is something that all of us are looking forward to as scholars of South Asia. So without much more ado, please join me in welcoming Dr. Namita Wahi to the 2021 CSA lecture series. Welcome, Namita.
Good evening, everyone, and good morning for all of you there. Thank you so much, Mo, for that kind introduction and for inviting me to come and speak at the center. Thank you to Sarah and to Tyler for organizing this as well. As Mo said, I was eagerly anticipating this moment as well because we have been planning this for a long time. And I'm really looking forward to presenting my research, which has been going on throughout the doctoral period and for almost as long a period afterwards, which is a history of the right to property in India. So if I can just share some slides to support my talk, as Mo mentioned, I've been working on the history of the right to property, throughout my doctoral thesis, and my doctoral thesis looked at the history of the right to property, starting from the colonial period up until 1967. And what I've tried to do since then is to take the research forward up to the abolition of the right in 1978. And that is the plan for the proposed book project, which is tentatively titled The Right to Property and Economic Development, How Property Saved Democracy in India. And it's hard to summarize the research of a book project in the space of a lecture, but I'll try my best to give you a sense of the major arguments and supporting evidence. And also the book is not finished yet, so feedback is going to be extremely welcome as I think through this. So first, just to set the context for what we're talking about. India's experiment with constitutional democracy started in 1946, even as the terms of Indian independence were being worked out. Some have called it a reckless experiment with democracy, just to get a sense of what we are talking about. I mean, I think the whole world is thinking about India right now, but this is a map of India pre-partition, which encompasses, as you know, what is now Pakistan and also Bangladesh. And this is a map of India in the post-partition period. India is a country of 1.3 billion people today. It's called a subcontinent. But at the time of independence, it was about the population of the United States. It was about almost 350 million people. And many called it both an unnatural nation. I mean, that was the British argument for denying independence as long as they did, because it was constructed out of diverse peoples. and deeply divided on the basis of caste, class, ethnicity, and religion. It's also been described as an unlikely democracy. It was the first country at the time to not only have a constitution drafted entirely by its own nationals, but they took a decision that many described as reckless, which was to give universal adult franchise to everyone from the very beginning. So a desperately poor and illiterate population was given the right to choose their representatives and who were going to decide their destiny. And contrast this with the US Constitution, which did that only 150 years later, or with the UK, where actually universal adult franchise really came about after India gave universal adult franchise. Also, the remarkable thing about the Indian Constitution was that it was drafted in great part by Dr. B.R. Ambedkar, who belonged to the Dalit or erstwhile untouchable caste. So not only the fact that everyone, including women and lower castes and backward castes, got the right to vote with everyone right away, but also our constitution was drafted by a Dalit. And over the last 71 years, India has been celebrated as the world's largest democracy, barring a brief interruption of democratic rule from 1975 to 77. This year, of course, there has been a questioning of India's democratic status by the Wiedem Report, as well as by Freedom House. But for the purposes of this book project, India's current situation is outside the scope of this book. The scope of the book, however, the arguments in the book, I think, are quite relevant to the situation we find ourselves in today. Just to give you a sense of the universal adult franchise exercised, these are the flags of two of the political parties. The story is really about the first on the left-hand side, where the Congress, although the argument of the book about a dominant party is applicable today to the BJP as well, which is the dominant party today. So, some facts about the Indian Constitution. As I mentioned, it was the first constitution to be drafted entirely by its own nationals. The Constituent Assembly was composed of members that had been elected indirectly by members of provincial assemblies, where elections had happened in the 1930s. So British India, that map that I showed you, had princely states as well as territories that were directly administered by British rule, and there were representatives both from within British India and from the princely states. There were only 13 women who were part of the drafting committee, and the Indian Constitution is the longest written constitution in the world. It was drafted over a period of 3 years, from 1946 to 1949, and it came into force on 26 January 1950. It is a constitution, unlike the US Constitution, very easy to amend. Parliament alone can amend most provisions, and for some we require ratification by state legislatures. Not only is it the longest written constitution in the world, it's also the most amended constitution, with over 100 constitutional amendments in the last 71 years. If we, these are images of the Constituent Assembly when the Constitution was being adopted. Some of the important people in our story are in the first and the second picture. So we have Dr. Rajendra Prasad in the center, who was the first president of independent India, the president of the Constituent Assembly. We have Jawaharlal Nehru, who was the first prime minister of independent India. Dr. B.R. Ambedkar is the person on the right, who is the chairperson of the drafting committee and the person to whom a large amount of the credit for drafting the constitution goes to. In the right-hand side picture, the second person that we see is Sardar Patel. He was the first home minister. He was also a very important figure in the Constituent Assembly, as we will see. In some ways, today has been a difficult day to give this talk, and this month has been a very difficult time for India. But I think that, in some ways, the founding of India also happened during a very difficult time. It happened during partition, which featured the largest mass migration in human history, when 6 million people crossed borders. And while this was happening and there was carnage breaking out, is when the Constituent Assembly was debating the Constitution. India is a union of states with we have a federal government, but with a unitary bias. So it's the opposite of the US, where residuary powers of legislation are with the center. Also, the center has more powers to legislate compared to the states. We have a parliamentary system of government with a presidential head and multiple political parties. So our president is not as powerless as the UK Queen, but nowhere as powerful as the US President. We have Parliament and state legislatures who are elected on the basis of universal adult franchise. The executive is appointed from members of the ruling party, and it is, in theory, supposed to be accountable to the union and state legislatures. We have an unelected bureaucracy, unlike the United States, with significant continuities with the colonial bureaucracy. There was a lot of debate about the continuation of the bureaucracy in its existing form between Patel and Nehru, and Patel actually won that debate. The bureaucracy of India was called the steel frame of India. We have a unified judiciary. So I want to just draw attention to this because we have a union of states with a unitary bias, and we have a unified judiciary. This is what the Parliament of India looks like, and this is the building, the Supreme Court building, which is architecturally designed in the form of the scales of justice. And this is the executive, the Union Executive in North Block. So the Constitution represented a commitment on behalf of we, the people of India, because even though the Constituent Assembly was elected on the basis of limited franchise, the Constitution provided for universal adult franchise at the outset to be governed by elected representatives according to the rule of law. And this is very important because the principle of rule of law permeates all written and unwritten guarantees in the Constitution. The Part 3 of the Constitution guaranteed to all citizens fundamental rights to life, liberty, equality, and property. But all of these rights, again, unlike the US Constitution at the time of its adoption, these rights were not absolute, but were made subject to reasonable restrictions in the public interest. And any law which violated those rights would be unconstitutional. At the same time, the Indian Constitution had a remarkable feature called non-enforceable directive principles of state policy. These have what are often been described as social and economic rights in the Indian Constitution. So, for example, Article 38 provided that the state shall promote, so it's a mandate to promote the welfare of the people by securing a social order in which justice, social, economic, and political shall inform all institutions of national life, and that the state shall strive to minimize inequalities in opportunities, status, facilities. The state shall also direct its policy towards securing that ownership and control of material resources of the community are so distributed as best to subserve the common good, and that there are no concentration of wealth and means of production in the hands of a few. So these are commitments that are in the text of the Constitution. And they also include rights to livelihood and living wage, where the state has an obligation to secure that men and women have the adequate right to an adequate means of livelihood, and that there's equal pay for equal work for men and women, and that there is effective provision for securing the right to work, education, unemployment, old age, sickness, and disability assistance. The difference between the fundamental rights and the directive principles is the fact that the former were made judicially enforceable, whereas the directive principles have been made judicially non-enforceable in the text of the Constitution. Now we come to property in the Constitution. The fundamental right to property was the most debated provision in the Constituent Assembly after the provision on official languages. And it is the only fundamental right to have been ever abolished. So think of the paradox, right? This is the most debated right. The debate on the fundamental right to property began even as the terms of independence were being worked out. So that's crucial. They debated on it for 3 years. They came up with with two provisions in the Constitution, Articles 19 and 31. 19(1)(f) says that all citizens shall have the right to acquire, hold, and dispose of property. And of course, this was not an absolute right, and there were restrictions that could be imposed, reasonable restrictions in the public interest. But think of it like this is a right which has been debated for so long, and yet it got abolished. So what went wrong? And that's really what my story is all about. Article 31 of the Constitution basically codified what we call the eminent domain or expropriation power of the state, which allows the state to forcibly acquire property of individual citizens only pursuant to a validly enacted law, and only if the acquisition is for a public purpose and the law provides for compensation. Now, Articles 19(1)(f) and 31 guarantee justiciable property rights. The exceptions to justiciability were also included in the Constitution, and that explains why the debate was so tortured. Basically, the provision ousted judicial review of pending land reform legislation. So remember, the provincial legislatures were already in place even before the Constituent Assembly was drafted. The Constituent Assembly sat to draft the Constitution. So there is a provision which said that pending laws, will not be subject to judicial review under Article 31, and it excluded laws affecting property rights in the exercise of taxation and police powers from the requirements of compensation. Because as we know that there are sort of 4 powers that are inherent in a state sovereignty. There is taxation, there's police powers, there's eminent domain, and there is the law, the power to conduct foreign affairs. That is what 4 powers that constitute a nation's sovereign power. So the compulsory acquisition property requirements were not applicable to enforcement of taxation and police powers. So now to think about this clause, why were these clauses, Articles 19(1)(f) and 31, and I don't want to be too legalistic, but these are the 2 provisions to keep an eye on, Article 19(1)(f) and 31, because these are dead rights. They're no longer there in the Constitution, but the history of their life has a lot, I think, to tell us about democracy and economic development and rights in India. So what we find is that, when I look at the intellectual currents in social and political movements that led up to the drafting of the Constitution and then the debates in the Constituent Assembly, there are 2 dominant discourses which frame the debate over the adoption of the right to property. The first is the rights discourse, and the rights discourse has 2 components. There is a component of political equality. This is a country where people are going from being, subjects of an alien power to becoming citizens. And, these subjects had, since the very inception of the Congress in 1885, so 10 years after that, the Congress, started the Home Rule Bill, and then it culminates for over 100 years later in the Subgroup Committee report of 1945. But for all these more than 100 years, the demand has been the demand for rights has been for a long time, but in terms of actual provisions from 1895 onwards, there is a demand for basic rights against arbitrary British rule, because the people of India before independence have no say in the laws, in the actions that are being taken. The laws are framed either by the British Parliament, like the Government of India Act, or the laws are made by a colonial government. They have no say, and as a result, they are subject to arbitrary power of the British state. And so the demands for rights date back throughout the independence movement. The second aspect of the rights discourse is that it's a dignitarian discourse. And this very much comes from, the experience of Dr. Ambedkar as a Dalit, who has suffered the indignities of Indian society. And so the idea of imbuing the Constitution with these fundamental rights is that we have to have rights premised on the dignity of each individual to realize their full potential as human beings and equal citizens of newly independent India, because India was a society deeply divided on the basis of caste, class, religion, ethnicity, and gender. And so the individual becomes the center of this idea, and the dignity of the individual becomes important, because within the caste system and also with respect to gender, like women don't have the same rights as men, and lower caste men don't have the same rights as upper caste men. The second very important discourse, which is not looked at within histories of constitutional law so much, is the development discourse, which focused on poverty alleviation and improvement of living conditions of all Indians. The development discourse is something that sort of came about in the post-World War period, because for the first time, there was this idea or this belief that if we do certain things, then development will happen. And what were these things? So this development discourse, suggested that for development, India had to move from a feudal agrarian society to a capitalist industrial society through the initiation of land reforms, state planning and control of heavy industry, and through encouragement of growth of private industry in other areas. Unlike the rights discourse, which is premised on the dignity of the individual, it's a dignitarian discourse. The development discourse is a utilitarian discourse, which empowers the state to take coercive actions against individuals and groups, premised on the philosophy of the greatest good of the greatest numbers. We have to lift everyone out of poverty, which means that we may have to take away rights from some people, or we may need to initiate measures that work to the advantage of work to the disadvantage of some. So it's a premise on the greatest good of the greatest number. And as a result, there was a fundamental contradiction at the very outset between the development discourse and the rights discourse. To give you a sense of what we are talking about, India's population at the time of independence is about the US population right now, and it has grown steadily in the last 70 years. So that we are now 1.3 billion today. And this population at the time of independence is desperately poor, and life expectancy in India, we don't even have proper figures for in 1947, but we know that it's less than 40 years. So the average Indian is living less than 40 years. The literacy rate of the population is 18%. We are giving universal adult franchise to a population in which only 18% are literate. And that doesn't mean they're educated, they're literate. The numbers for women and Dalits and Adivasi groups is even lower. Less than 10% of India's population at this time is literate. India's GDP is extremely low. And as you see, there is a steady growth in the GDP up until, in the period of this book, the growth is quite slow, is in the range of 3 to 4%. And then it sort of goes up in the 90s. Per capita income is also extremely poor. The average Indian is earning only about 7,000 rupees per year. Development expenditure as percentage of GDP is something that we see steadily rising as well. As the country becomes richer in terms of GDP numbers, more and more money is being spent as part of what we call development expenditure. So even though there are these two broad discourses which are framing the debate on the right to property in the Constituent Assembly, they are not homogeneous. There are no homogeneous views within the discourse. There was a lot of diversity in the Constituent Assembly on what rights should be secured and how development should be achieved. So on rights, they were, the first group of people, which this is something that actually everyone sort of agreed with, was that civil and political rights consistent with political liberalism, which provide a safeguard against arbitrary exercise of power by the state. This was supported by majority of the people. Remember, most of these people are people who have fought in the freedom struggle and faced arbitrary action, arrests by the British. And so all of them are in support of basic civil and political rights, including Nehru and Patel and Ambedkar. There's a second group which is really focused on bringing social and economic rights consistent with socialist thought within the text of the Constitution. This group includes the Congress Socialists led by Nehru. It also includes the Communist Party, which is not in the Constituent Assembly because they didn't contest, because they didn't win in the elections that led up to the Constituent Assembly. But because outside they are responsible, outside of formal politics, they are behind organization of trade unions, organization of strikes. The communist threat is what leads. So the socialists are sort of the more moderate form of similar demands. The communists want a radical communist state. They are not part of democratic politics at this time, but it is their demands and the fear of communist revolution that also pushes these ideas onto the table. And also Ambedkar, who of course was, who was participating in the depressed classes conference, who was speaking on behalf of the lower castes. For a while, he also tried to forge an allegiance between caste and class. So social and economic rights is again consistent with the views of a lot of people. And that's why, at the time of drafting, we don't actually have a separation between enforceable civil and political rights and non-enforceable directive principles. The separation comes much later. In the beginning, they are being all deliberated upon together. The third is property rights. And it's interesting because at least in the US Constitution and up until that time, property rights are considered as part of civil and political rights. Property is considered intrinsic to democracy in that sense. But in India, property rights were sort of reviled. In fact, property rights were the only rights of the zamindars that the British had protected previously. And we have some zamindars in the Constituent Assembly, including Kameshwar Singh, who I'm mentioning because he's going to come up later in this story as well. We also have some industrialists. But many Congress leaders, including Sardar Patel and Rajendra Prasad, are also supporting property rights. Sorry. And then finally, we have what I call in the book the bottom 60%, which is the population of India consisting of women, who are about half the population, Dalits, and Adivasis, who are the indigenous communities. These are the people, remember, who have a less than 10% literacy rate and very few rights compared to the rest of the population, even at the time of independence. Everyone wants to do something to improve social subjection of women, Dalits, and Adivasis. Nehru, Patel, Prasad, Ambedkar, as well as the 13 women in the assembly, especially Amrit Kaur and Rajkumari Amrit Kaur and Durgabai Deshmukh. Similarly, within the development discourse, there is a diversity of thought at this time. So, except for Gandhi, who is not participating in the Constituent Assembly, he is just trying to bring relief in the country struck by partition and is assassinated in 1948. There is a consensus amongst all Congress leaders that state plan development focused on industrialization and capital formation is the way forward, and that is the development consensus. Some people want to take it a step further. Nehru is one of them. The Congress socialists are not just state plan development is not enough. They want to actually bring about socialism. The third aspect of consensus is on land reform. So we have to have land reform. We have to, but how should we bring it about? The only consensus is on the abolition of zamindari. There is no consensus on other, and India has many land tenure systems at this point. We have the zamindari system, we have the rayatwari system, we have the mahalwari system. There is consensus that zamindari must go. How it should go, there is no consensus. The debate rages for 2.5 years. It continues up until the adoption. And finally, with respect to Adivasis, who are represented in the assembly, there are two representatives. Adivasi community, like indigenous communities everywhere, have a unique relationship with land. Land is central to their community, identity, and culture. But they don't think of land in terms of property rights. They think of it in terms of community, identity, and cultural rights. And there we see a cleavage as well, because the dominant Congress narrative is that the Adivasi communities have to be integrated through development within Indian society, contrary to the British policy of what I call in our scheduled areas report as the identity-based isolation narrative. On the other hand, the tribals community, we call them the scheduled tribes or the Adivasi communities, they actually are asking for limited sovereignty or autonomy over territory that was administered as the scheduled districts and now the scheduled areas under the Indian Constitution. So this is what was happening within the Constituent Assembly, but things change while the debates are going on. India becomes independent. India and Pakistan, India is partitioned into India and Pakistan. So already the Constituent Assembly is heavily dominated by the Congress. 70% of delegates are from the Congress. But after partition, 90% of the delegates are from the Congress. So the Congress is really dominating. India then opts for a parliamentary system of government with the first past the post system. So in a first past the post system, you can get elected if you don't have the majority of the votes, so long as nobody else has the majority of the votes, right? So what we find is that as India finds itself independent with a constitution, it also finds itself with a dominant party. A dominant party is a thesis put forth within political science literature by the Rudolphs, who have said that a dominant party is one who exercises power for many terms and commands consistently large majorities of seats over a period of time. They also say the party that have been leading freedom struggles against colonial rule become dominant parties. So if we use the metric of durability and incumbency, then let us look at the statistics of Congress rule. So the first 3 general elections, the Congress won 3/4 of all seats in Parliament. And it also had about 45% of the vote share. In the 1967 general elections, for the first time, the seats fell to over 50%, but it's still over 50%, and the vote share dropped to 41%. And in 1971, the Congress seat share in Parliament again rose back to 68%, and vote share again got back to almost the levels it was before 1967. So for the period of this book, 1950 to 1970, from 1946 to 1978, the Congress can be called a dominant party. By the time we come to 1975, when the emergency is declared, the dominant party becomes authoritarian. What is the conventional scholarly narrative about property? Why am I reviving these dead rights? Why is this important? So the conventional narrative within constitutional and political science literature on judicial review of property rights has been that the judicial enforcement of property rights impedes distributive justice goals because those who lack property or who have experienced deprivation of property entitlements are unable to provide for their basic needs. So you should not give courts the power to protect property rights because it prevents the state from bringing about distributive justice. Social redistribution programs such as land reform that inevitably seek to alter existing property arrangements in order to meet these goals, to fulfill the social and economic needs of the poor, are impeded by justiciable property rights. In the context of India, the narrative that we have about the fundamental right to property was that it blocked uplift of the poor. This is because the Supreme Court impeded land reforms introduced by a progressive parliament. A reactionary court impeded land reforms introduced by a progressive parliament. And it is based on this decision it originates with this decision of the Patna High Court on Kameshwar Singh versus province of Bihar. This was a case where the Patna High Court found the Bihar land reform law unconstitutional for violating the right to equality, not property. And it found that this graduated scale of compensation in relation to the size of land holdings set up an unreasonably discriminatory classification on Article 14. So again, not to be too legalistic, I had asked you to remember two provisions, 19(1)(f), which is the right to acquire, hold, and dispose property, and Article 31, which codifies the power of eminent domain. That is, it puts constraints on the state's power to take away property. The third provision to remember, and it's similar to the 14th Amendment in the US Constitution, is Article 14 in the Indian Constitution, which is really about protection against arbitrariness and the right to equality. So there was this Patna High Court decision which was sort of going against the express wish within the Constituent Assembly, but at the same time, there was a decision by the Allahabad High Court, where also land reform laws were pending. So land reform laws were pending in 3 provincial legislatures. One of them struck the law down on the ground of arbitrariness. The other one actually upheld the law. And it said that, well, you know what, the law has to be read in light of the non-enforceable social and economic rights outlined in the directive principles. It's going to secure workers a living wage. It's going to prevent inequalities, etc. So we are going to uphold the law, even if it is not paying full compensation. So what happens is that in 1951, Kameshwar Singh and Suryapal Singh both appealed to the Supreme Court. Remember, Kameshwar Singh is also someone in the Constituent Assembly. He's part of the group who wants to retain protection for property rights, but he's not the only one. What happens in 1951 is that Parliament goes ahead and amends the Constitution. Remember, it's a Indian Parliament. The Indian Constitution is easily amendable. That's why we have over 100 amendments. Parliament alone can amend a lot of provisions of the Constitution. But remember, there is no Parliament, but because in 1952 is when we have the first general election. So actually, it is right now the Constituent Assembly sitting as Parliament. So they basically go ahead and amend the Constitution that they themselves have drafted, right? And they insert Articles 31A and 31B in the Constitution and append the ninth schedule to the Constitution. Now, it may appear from this that, you know, obviously the court got it wrong because these are the same people who drafted the Constitution. It didn't read the provision properly. It's done the wrong thing. So that's why they had to go ahead and amend it. That's been the conventional narrative. And now they include these express provisions which oust judicial review of land reform laws on grounds of violating fundamental rights. And they also oust judicial review of all laws inserted in what is called the ninth schedule of the Constitution. And what they do is that they go and insert all the 11 land reform laws in the ninth schedule, including the Bihar and UP laws, so that the Supreme Court cannot look into this. What happens in 1952 is that the Supreme Court, even though the Constitution has been amended to actually prevent judicial review of land reform laws, it goes ahead and still invalidates 2 provisions of the Bihar Land Reforms Act. And you could think why this would outrage Parliament, right? Like they've been trying to make it clear that you can't look into land reform laws, but the court is still doing this. But just like the high courts had done, it upholds the UP and MP laws. What is less well known, and this is what gets the court the reputation of being a pro-property rights court, but in 10 subsequent land reform cases, the Supreme Court goes ahead and upholds all land reform laws on grounds that the newly introduced articles have ousted justiciability of fundamental rights. So land reform laws that oust intermediaries in Uttar Pradesh, Madhya Pradesh, Madras, Bombay, Orissa, basically everywhere where we have the zamindari system are upheld. But the conventional narrative sticks. So the idea is that the parliament is very progressive. It wants to bring about development. It wants to bring about progress, and the court is reactionary. As a result, we have a situation where, Parliament goes on and on to amend the Constitution. The first amendment, as I mentioned, was in 1951, which ousted judicial review of zamindari abolition laws and introduced the 9th schedule in the Constitution. Then we have the 4th Amendment in 1955, the 17th Amendment in 1964, which amends the definition of estate to include rayatwari land systems. The 25th Amendment, which replaces the word compensation with the word amount. And finally, there are many more amendments. These are the most important. It abolishes the right to property. It takes away 19(1)(f) and 31 from the Constitution. It introduces a new provision, which is no longer a fundamental right, but it is still there in the Constitution, saying that nobody's property will be taken away through arbitrary executive action. It has to be by law, but there's no requirement of public purpose or just compensation. So why did I decide to revisit this story? Because there has been, in recent times, there has been a questioning of this narrative on the right to property. On the one hand, we've had the neoliberal critique, which has come from people like Hernando de Soto, who have said that, no, property rights are not bad for the poor. They are critical to unlocking capital, the potential value of assets, which is a precondition for economic growth, and they're necessary for eliminating poverty in developing countries. As a result of which, the World Bank has financed programs for land titling and for securing property rights. Because the idea is that the absence of conclusive property title marginalizes the poor because it prevents them from securing loans for their property. Similarly, we have the land titling bill and the digital land records modernization program, as well as the Swamitva scheme recently, all of which are in pursuance of this neoliberal idea. At the same time, we've had social movements like the Ekta Parishad, who have critiqued state acquisition of land for development and have sought land rights of the poor and landless communities. And so what we have is a left narrative on the right to property, where they have argued that widespread land acquisition by the state has dispossessed poor peasants in traditional communities like forest dwellers, cattle grazers, indigenous fishermen, and tribals. Scholars are now suggesting that the court may have weakened property rights too much, that they have actually dispossessed the poor rather than the rich. And the Supreme Court has made the right to property justiciable again recently through creative judicial interpretation. They've also enacted the Right to Fair Compensation and Transparency in Land Acquisition Act to include these requirements. There was also a petition filed in 2010 by Sanjeev Agarwal, who sought invalidation of the 44th Constitutional Amendment and reinstatement of the right to property, because of massive and widespread displacement of poor people due to state-led projects of economic development. The Supreme Court dismissed the petition, but it said that it may hear the case in a more, the petition may be refiled in a more appropriate case. Similarly, in other judgments, it has reinstated the requirements of public purpose and compensation within the new provision. So now let's talk about constitutional courts in property. So within the Constituent Assembly debate, there was a debate on whether the right to property should be judicially enforceable. And there were three views within the Assembly. The first group, led by Nehru, believed that the legislature should be the sole arbiter of compensation in all cases. Now, this group included both socialists and believers in legislative supremacy. The second group, led by K.M. Munshi, believed that the individual's right to property mandated that full compensation should be paid in cases of acquisition, even in the case of zamindaris. Courts, not the legislature, should be the final arbiters of what constitutes adequate compensation. And this was in line with sort of the British policy as well, because the earlier law, which was the Land Acquisition Act of 1894, you could go to court and it said market value compensation. The third group, led by Ambedkar, Patel, and Krishnamachari, took the middle ground, arguing that while the requirements of full compensation and judicial review of adequacy should not apply in the case of zamindaris, they should apply in all the other cases. So there was a lot of debate with these three views. The only consensus amongst these groups was that zamindaris should go and that industrial property should be protected. There was no consensus on how should we arrive at just compensation. The straightforward story appears that, the Constitution was very clear, and what the court did was contrary to the people's will as expressed in the Constituent Assembly, and that's why they had to amend the Constitution, and they had to keep amending the Constitution. But the truth is that actually the Constituent Assembly was very divided, and that's why this clause was debated for as many years as it was. But things changed. Something happened which allowed the Parliament to speak in a more united way than the Constituent Assembly. One thing that happened, as I mentioned, is that, after the partition of India, one of the principal political oppositions representing a minority group, the Muslim League, is no longer there. After the assassination of Gandhi, with the ban on the RSS, for a while, even the RSS is not as active. But even within the Congress, where there are multiple power centers, what happens in December 1950 is Patel dies, leaving Nehru as undisputed leader of the Congress party. In 1951, when Nehru moves the first amendment to the Constitution, remember, Ambedkar is never a part of the Congress. He has his own party. He's brought into the drafting of the Constitution, and he's also brought into the first government. But, it's an unhealthy, it's an uneasy relationship. So Nehru moves the first amendment to the Constitution with Ambedkar's support, noting that the delays caused by litigation will delay land reforms. But this support is fraying, and one of the things for this support was also the reform of Hindu society through the Hindu Code Bill. So Ambedkar supports Nehru on the First Amendment, but later that year, when Parliament stalls the Hindu Code, he resigns from government. And it's very interesting and not as well known that in 1952, so Ambedkar has supported the amendment of the Constitution in 1951, but in 1952, he's actually appearing on behalf of the zamindars, because Ambedkar is a lawyer, as you know, before the Supreme Court, arguing that taking property without compensation in an arbitrary manner goes against the spirit of the Constitution. This is the man who's written the Constitution, and he is in 1942 saying that, taking away property without compensation went against the spirit of the Constitution. In 1956, Ambedkar dies, leaving Nehru to define the legacy of the Constitution. The right to property Nehru goes on to amend the right to property through the Congress 3 times before he dies in 1964. After Nehru, Congress remains dominant and Indira becomes authoritarian. So Nehru dies in 1964. In 1967, the 4th general elections. This is the first general election where all the founding fathers of India are dead. So in 1967, by a 7-6 majority in the Golaknath case, the Supreme Court, because by this time there have been more than 17 amendments to the Constitution in 17 years. So the Supreme Court in the Golaknath case, holds by a wafer-thin majority that there are limits to Parliament's power of constitutional amendment. Parliament cannot abrogate fundamental rights. So this happens in 1967. In 1969, there is a split between the Congress, and the Indira Gandhi-led Congress remains in government with outside support of communists till 1971. While, before the split happens, Parliament, there is an ordinance through which banks are sought to be nationalized. In 1970, the Supreme Court strikes down the ordinance, and the ordinance is later replaced by a law which is also struck down as arbitrary and violative of the right to property. This is the bank nationalization case. Then in 1970, Congress tries to abolish privy purses through constitutional amendment, and there isn't even consensus within the Congress to do it. So it fails, and therefore it amends it through a presidential order. In December 1970, the Supreme Court strikes this down, noting that the Constitution could not be amended through executive order. So you see now the conflict between the court and Parliament is intensifying between 67 and 71. In 1971, again, Congress becomes the dominant party, even if its dominance had declined in 1967 and it split. So there was a lot of fissures there. It becomes dominant again. In 1972, Indira Gandhi passes a series of constitutional amendments to overturn the Golaknath bank nationalization and privy purses cases. This leads the Supreme Court then in 1973 to say that you just can't go on amending the Constitution like this. Yes, you can amend fundamental rights, but you can't amend what is the basic structure or the spirit of the Constitution. Indira Gandhi doesn't like that. In 1975, she declares a state of emergency and all fundamental rights are suspended. In 1978, the Janata Party government abolishes the right to property. So my revisionist account of this period that I've just described is based on a comprehensive review of 1,616 Supreme Court and High Court cases involving a challenge to the right to property. The review of these cases shows that the Supreme Court and High Courts actually share Parliament's vision of economic development and industrial growth as progress, which is derived from the development discourse. So they're agreed on the development bit of the right to property. They're not agreed on the rights bit of the right to property. The disagreement is primarily arising in two sets of cases. There is a fear of arbitrariness, where the court is agreeing with the broad scheme of social and economic welfare. So there's plenty of language in the cases which says land reforms are good, land reforms are necessary, we have to lift people out of poverty. But they're saying that this particular law, the way you've drafted it, is discriminatory without a rational basis, or it distinguishes between similarly situated parties in a discriminatory manner, or it creates a lot of potential for arbitrariness on part of the executive, which is the one branch of government which has not been reformed at all from the colonial period. So the courts are, we have lots of new courts. We have the Supreme Court is new. It was created in 1950. Parliament is new. Our executive is the same as from British times. So even though there is consensus, and so that's the first set of cases where there's a fear of arbitrariness. The second set is where there is no consensus in Parliament about, so there is consensus about the overall social goal, aka development or land reform, but there is no consensus within Parliament about particular measures for achieving that goal. Like I described, there are like three views about how to do this on the specific, how much compensation, who shall review compensation. There is a lot of disagreement. So in this context, and that's the argument of the book, is that the court serves as a site for mediating tensions between the majoritarian will of the dominant party and the political opposition, which is ineffective in Parliament because of the Congress being a dominant party. And just to show you, so, if you remember, the Article 19(1)(f) and 31 are the right to property clauses in the Constitution. Article 14 is the equality guarantee, and Article 19(1)(g) is the right to pursue a profession, trade, or business. Now, if you see, in both the Supreme Court and the High Courts, when we look at all the property cases, Article 14 is invoked almost as much, sometimes more than even the property clauses in the property cases. So the real issue before the court is this worry about arbitrariness. The issue is not so much that property rights are sacrosanct, but the fact that if you're going to take away someone's property, you have to follow procedure established by law. Similarly, if you look at the purposes of litigation, why are people actually going to court? So at the Supreme Court, only 20% of the litigation is about land reforms. If you take a whole view of the litigation as opposed to the cases that got the most political attention. There are more cases on taxation where people are saying that your tax policy is confiscatory or your taxes are arbitrary. There are a lot of cases on land acquisition, not for the purposes of large-scale social reform, but just land acquisition for various projects. There are cases on licensing. There's a lot of cases on religious property at the Supreme Court level. At the High Court level as well, we see the same categories of cases. There are cases on licensing where people are suddenly somebody is denied a license, or somebody is under the Essential Commodities Act, it says that all licenses will be done away. What are people going to do in a situation like that when their source of livelihood is completely taken away? And so very interestingly, what's coming out is that the property right is not just a right to protect what we understand as actual physical property, land, or a dwelling or something like that, but also means of livelihoods. And we see that in the service matters, which are about bonus, pensions, things like that. We see that in cases of confiscation of goods that people are using for their business and so on, but the penalties may be more extreme than would be justified, and that's why they are going to the court. So there are lots of cases. I'm not going to go through all of them since time is limited, but I can return to them in the question and answers. So to conclude, constitutional courts have, in political and constitutional law literature, have often been critiqued as elitist, counter-majoritarian, ineffective. My revisionist account of this period, where the Supreme Court is actually regarded as elitist and counter-majoritarian, actually a study of these 1,600 cases shows that the courts are actually enhancing democracy, because what they're doing is that in a post-colonial state where the executive is very much, there are institutional continuities, which is conditioned to act in a manner that is not consistent with democratic rights. And with a parliament, in a parliamentary system of government works if there are enough political parties that can exercise control. But where there was a dominant party, the court is not only giving a space to minority voices, which is traditionally what courts are understood to do, but also to a silent majority that is unable to resist the agenda of the dominant party simply because it's too diverse and it doesn't have the institutional mechanisms through parliament to voice that opposition. In all former British colonies, courts were historically playing this role throughout British rule when there was no representation of people in government. So high courts in India, the Madras, Bombay and Calcutta high courts, they predate the constitution. They are from the 19th century and they have continued as such. So basically what I conclude is that the right to property in India was less about property. It was more about rights and resistance against arbitrary state action in the way that it has been interpreted by the courts. And that's the rights discourse playing out. The problem, however, and this is the criticism of the courts today, is that the courts are aligned with government on the development discourse. And that is also an important insight that comes out from the work, is that in constitutional democracies like India, we can't just remain within the rights discourse. There is in developing countries that are also constitutional democracies, a hegemonic development discourse almost always trumps the rights discourse. Yes, there are occasional victories that you get where you protect indigenous people's rights against major industry. But if the development discourse is premised on prioritization of industrial growth and infrastructure growth, then you are going to privilege the urban over the rural and industry over agriculture, not just in parliament, but also in courts. The only check the courts can provide is about controlling arbitrary action, which is something that they've been doing both during British rule and during the period under study. So I think I'll stop there.